Thank you to everybody for joining us today. My name is Sarah Hart, and I'm a partner in our Edmonton office, co-lead of Denton's professional liability subgroup, and member of Denton's litigation and dispute resolution group. My practice focuses on professional negligence claims, commercial litigation, and as well as shareholder disputes. And I represent individuals, insurers, and corporations before all Alberta courts and tribunals. Today, I am pleased to be joined by my colleagues. Firstly, Karen Grew. Karen is a partner in Denton's construction, litigation, and real estate groups with deep experience representing owners, contractors, and design professionals in construction disputes, professional negligence claims, and product liability matters. A recognized leader in e-discovery, she has been instrumental in shaping national guidelines on electronic document retention and production. Secondly, Michael Sestito. Michael leads Denton's Edmonton Litigation and Dispute Resolution Group and represents owners, contractors, subcontractors, and professionals in complex construction disputes and professional negligence matters. He has acted on major infrastructure projects and appears regularly before all levels of court in Alberta as well as in Ontario. Today we are speaking on unpacking the key risks and exclusions in professional liability for architects and engineers. And I'm firstly going to call on my colleague, Michael Sestito. And Michael, I was hoping that you could take us back to some of the critical basics that are important for us to know, such as what constitutes a professional service, as well as scope of coverage and exclusion issues. So if I could turn it over to you to start.
For sure. Thanks for that, Sarah, and thanks for everyone for joining us on this early December day. I'm sure for those of us registered to practice in BC and Ontario, I'm sure it's no coincidence that you're spending the next 90 minutes with us today. It's always great. Every year I tell myself I'm not going to leave my CPD requirements until December, and every year here I am. So I'll be hopping on another webinar after this, and a desperate attempt not to spend my wee hours between Christmas and New Year's catching up on my CPD requirements. So welcome everyone, and we're really glad that you can come with us. 90 minutes to discuss professional insurance, to discuss liability and construction matters. So it'll be very riveting, I'm sure, and we'll do our very best to keep you awake for most of the 90 minutes, but I can't make any promises. So yeah, absolutely. Let's start by talking about the sort of basics of what are the distinctions in coverage and what are scopes of coverage, and maybe we can just advance to the next slide. So generally speaking, and this is a very general statement, but generally speaking, when we're looking at insurance in the context of the construction industry, we're looking at two broad buckets of coverage. One is coverage for professional services, and the other is coverage for construction work. And this is generally speaking how insurers will distinguish between coverage when you're looking at construction services, generally speaking. So on the professional liability side, which of course this group here is very interested in, professional liability policies will respond to those damages or those losses that flow from the professional service. It's not enough that it's simply losses that flow from the person who is providing a professional service. It has to flow from the professional services itself. And we'll talk a little bit about how that is distinguished in the case law. The other side are construction general insurance, or it's liability arising from the construction process itself, right? It's not necessarily connected to a professional service. It's connected to the act of construction. So when evaluating coverage, of course, your number one question is going to be, are you looking at a professional services coverage question or a general construction policy, and what's the overlap there? Both of these types of insurance will have certain exclusion clauses that will govern where the policies would apply and where they wouldn't apply. And often those exclusions will be separate policies or products that are available that insurers don't assume in the general policy, but for which additional coverage can be purchased. Sometimes, of course, they can. Of course, the underlying rationale among this is that you want to keep payouts contained and premiums competitive. That's why there is, specific covered events and specific excluded events and excluded actions that you have to be very mindful of. So maybe we can focus on the professional services. Let's advance to the next slide. And let's spend a few minutes here chatting in general terms about what is a professional service. Um, we are here today providing you all with a presentation to explain the intersection between insurance products and the construction industry. A very interesting question would be, are Karen and I and Sarah performing a professional service today? If you ask our general counsel, the answer would be no. We are not providing you with a professional service, but I'm sure there's some creative lawyers out there that could try to make the counter argument. A professional service, in a general sense, is really an exercise within a recognized discipline in which you're applying some kind of a special skill, knowledge, or training to the function in question. And a sort of throwaway comment that we have here is, if the task can be performed by a non-professional, then it's generally not considered a professional service. Now, I'm sure there's a lot of non-professionals or non-lawyers out there who think that they can practice law better than a lawyer can. And in some cases, you might be right. But at the end of the day, only a lawyer can practice law under legislation, right? And so that's why we're saying a non-professional can't provide that professional service in actual fact. A lot of us may think that we're just as smart as an engineer. I do not hold myself, by the way, in that category. In fact, I think I'm much less smart than anyone with an engineering degree. I say this for the benefit of all my engineering clients. But regardless, the fact is, I can't, even though I might try to do a drawing, I can't stamp a drawing. I can't actually provide that professional service in actual fact. So the question that the insurance companies, the risk managers, and the courts will eventually determine is the action from which the loss flows a professional service such that professional liability insurance applies? And that is truly what in law is called a question of fact. And that was determined in the case of Chematics and Commercial Union that we'll talk about in a minute here. So examples of professional services, a lot of times professional liability policies will define and provide examples, usually non-exclusive examples of what can be a professional service, feasibility and certain related studies, surveying, design specification, technical information calculation, project or construction management. These can all be defined as professional services. And you'll see this sort of carve out or throw away carve out to say, for the avoidance of doubt, professional services do not include the day-to-day supervision of manual operatives, labor, and physical construction work usually undertaken by building or engineering contractors. So that's an example of what a carve out may be. All to say that you can look at the case law, and we'll spend a lot of time today talking about the case law, but everything starts with the wording in the policy and the wording in your agreement to really govern what a professional service is. But let's spend a couple of minutes chatting a bit about the sort of key case law or the key case on defining a professional service. So we can just move to the next slide. And you're in for a long haul when we start with the case law that probably is older than the average age of our participants. But anyways, we're going to go back to 1984 and the British Columbia Court of Appeal, where it was determined, spoiler alert here, I'll cut to the chase, it was determined that the provision by a professional engineer of a training manual was not a professional service. So let that one sink in for a moment. Intuitively, you may have some feelings as to whether or not that's the right decision, but it was determined in this case that even though you're a professional engineer and even though you are providing a training manual, that is not necessarily in and of itself a professional service. So in this case, a professional firm designed and supplied a pulp leaching plant for a US-based customer after construction was complete. The insured in that case kept a supervisor on site to train the operators and provide a training manual to the operators, really that flows from the professional services and design that his firm had conducted. The tower of the pulp bleaching plant was damaged when the operator failed to react properly to a pump failure, and the owner sued the insured, alleging that the insured failed to warn it about pump failure and how to handle such a situation. The services alleged by the insurer to be professional services excluded from coverage were the provision of an operating manual for the use of the company's personnel and for the provision of services. So it was the loss in this case stemmed from a poor operating manual. Now, the court determined that in this case, the provision of the operating manual was not a professional service. And they say the function of giving warning of the risk, which gave rise to liability, it would not necessarily be a professional service. And let's unpack that a little bit by moving over to the next slide. So the British Columbia Court of Appeal dismissed the argument that the services were professional. And one of the really interesting points here is that in the lower court decision and the argument of the insurer in that case, they really focused on the fact that the service was being provided by a professional engineer. And therefore it had the sort of indicia of a professional service, not dissimilar to a lawyer providing you all with some background information on the law concerning insurance in the construction industry. I am a lawyer, and so the initial sort of indicia is I'm providing a professional service because I'm always a professional, right? But the reason that this case is so important, even though it's a bit dated, is really the conclusion of the Court of Appeal, in which they say, and we've highlighted it there in the excerpt. I cannot agree that the fact that Chemetics in providing services availed itself of the services of a person with professional qualifications is determinative of the question whether the services provided were professional services. And so the real takeaway from the case is that it is not the individual that determines whether or not the services are professional, but the action performed by the individual. It needs to be examined. And really, at the end of the day, it all comes down to a question of whether the action being examined fell within the professional duties and standard of care of that professional. So it's not enough to just sort of look at the fact that he's an engineer or that I'm a lawyer right now speaking to. You have to look at the actual activity that is being done by that person. And so let's spend a minute then talking about those duties and those activities. Let's advance to the next slide. So the focus here on whether or not, first of all, something is a professional service is whether it falls within the ambit of the professional standard of care. And this is the same whether you're dealing with the construction industry, the health industry, the financial services industry. The question of whether something is a professional service is really answered by whether it's something that was one of the duties that the professional owed to the client. And so, referencing what we will affectionately refer to as the Bible in this field, which is the McLaughlin text on the law of architecture and engineering, is this concept of what is the professional standard of care. The architect or engineer owes a duty to exercise the skill, care, and diligence which may reasonably be expected of a person of ordinary competence measured by the professional standard of the time, unless a different standard is provided for in the contract for professional services. And that's a really important carve out that I don't want to say it's unique to our industry, but it's certainly more prevalent in this industry than others. Um, the question of the standard of care is never divorced from the agreement between the professional and the client. So it's something to very much keep in mind as to when you're evaluating whether or not something is within the standard of care, and then whether the standard of care was met, right? Um,
Sorry, Mike, I was just
yeah,
going to interject here and ask you a question, but in my experience when negotiating these types of agreements, often the standard of care that's applicable is the subject of much debate. If you're representing an owner or developer, they typically want to see an increased or heightened standard, best first class quality. There are various variations on the standard they may seek to impose, and there may be different reasons for that given the type of facility at issue. And in my experience, that can become a subject of debate with the party who's representing the architect or engineer who wants to make sure that they're not offside their insurance requirements.
it's a really good point. And again, it's something that where you practice, generally speaking, in the area of professional liability, you're used to a sort of global standard of care. But we don't really go into it too much. It's a bit outside the scope of this presentation, but a note simply to say that by contract, the standard of care can indeed be modified, and oftentimes is. And as Karen mentions, it's the source of a great commercial debate. And I think it actually leads very nicely. And I don't think quite planned this way, Karen, but it leads very nicely into sort of my next section here, which is to talk about interpreting insurance contracts and interpreting, governing agreements in general. The key takeaway there being, this all started by us discussing whether something is a professional service, and all to say that when making that determination, you should be, in addition to looking at, generally speaking, what are the standards of the professional, you need to look at the contract as well. And you need to see what that professional has been contracted to do in order to determine whether or not that was a professional service. But in general terms, and every lawyer on this call will groan because we can't use the word interpretation without talking about the SATVA case. And so this is a bit interesting. I find it interesting anyway. The SATVA case in the context of insurance or interpretation of insurance agreements, it kind of falls right in the middle of a series of case law that discusses how one needs to interpret insurance contracts, right, and insurance agreements. So SATVA is the watermark, and SATVA is sort of the starting place, even though sequentially it doesn't really flow. But the general principle from SATVA that we can all recite by heart is that when it comes to contractual interpretation, the question is a mixed question of fact and law, and the purpose of the exercise of interpretation is to determine the objective intention of the parties. And when you determine the objective intention, you need to review the words in context, using plain and ordinary meaning, and review ambiguities in light of the factual matrix. And of course, SATVA comes to the conclusion that commercially reasonable and efficient interpretations that accord with the practices of the industry are to be preferred. So how does SATVA fit into interpretation of insurance agreements? The sort of bottom line is that there are two categories of insurance agreements that will then apply the same framework from SATVA. One are standard form insurance agreements, and the others are not standard form insurance agreements. And when applying SATVA, the conclusion is that you would interpret these agreements like you would any other contract. The only difference is, in the context of a standard form agreement, the so-called factual matrix is almost irrelevant, because you're not entering into a negotiation between sophisticated parties, and so the objective intention is not going to be borne out through the factual matrix. So, I mean, that is a very short way to digest a series of very complicated cases, but that's kind of it in a nutshell. So let's take a look at some of these cases. So let's go to the next slide, and for the moment, I'm going to skip over Turcon. We're going to come back to that. So let's go to the next one, which is Progressive Homes. And now this is a Supreme Court decision that predates SATVA, but it will apply to the interpretation of insurance contracts. And the ratio or the rule from that case is the principles applicable to insurance contracts. So you'll see a lot of this will mirror what SATVA ends up talking about. So consistent. So when the language of the policy is unambiguous, the court should give effect to clear language, reading the contract as a whole. Where the language of the policy is ambiguous, the court should prefer interpretations that are consistent with the reasonable expectations of the parties, so long as that interpretation can be supported by the text of the policy. The court should avoid interpretations that would give rise to absurd or unreasonable results, and they should strive to ensure that similar insurance policies are construed consistently. Again, pre-SATVA, but you're seeing the similar analysis. So then the third sort of major principle from Progressive Homes, if and when the above rules fail to resolve ambiguity, the court construes the policy contra preferentum, which is against the party with the greater power, in this case, the insurer, with the corollary that coverage provisions are intended broadly and exclusion provisions are construed narrowly. So Progressive situates in the sort of recent law on interpretation of insurance contracts clearly in a sort of insurance-specific method. So then we go to the next case, which is Ledcor. If we could just flip to the next slide. So Ledcor, now we're post-SATVA. Ledcor has the benefit of the Supreme, well, I say benefit tongue-in-cheek because I have a lot of very strong feelings about SATVA and the giant Mack truck that can drive through whatever the heck factual matrix is. But let's leave that rant for another day. Ledcor is really trying to interpret progressive homes now consistent with SATVA, and it becomes what, in my view, is the sort of current seminal case on the subject of insurance policy interpretation. And I'm not just saying that because my good friend and partner Dennis Pico was one of the lawyers involved in the case. I actually do think this is where everything kind of is put together by the Supreme Court into a nice package. And so this case was the interpretation of a builder's risk insurance policy, which covered all contractors in construction. And it was it came to the conclusion that standard form contracts are unique and must be treated as an exception to the general principles from SATVA. Or read another way, the general principles from SATVA don't necessarily assist the court when reviewing standard form contracts, right? If you want to try to make it a bit more consistent. The relevant coverage provisions of the policy provide that all risks of direct physical loss or damage to property undergoing construction are insured, subject to certain outlined exclusions. And then the exclusion clause there that became the subject of a lot of discussion and judicial consideration is the cost of making good faulty workmanship. In Ledcor, there was an attempt to really broaden the factual matrix when it comes down to reviewing what the party's objective intention was for this exclusion clause. And without going too far down the rabbit hole there, the real takeaway is where you have an insurance contract that is truly a standard form contract, that analysis is less helpful, or one may even say not applicable. And that's sort of the reconciliation of SATVA in the insurance contract is with Ledcor, and there is a little bit of discussion on how that's applied, and I'll talk a little bit about SureSpan. But before I do, I don't know, Karen, I know this is a pretty seminal case. If you had any additional comments before I kind of wrap it up with the British Columbia Court of Appeal.
Not really, except that the facts of this case are kind of interesting, because in this particular case, the washing of the windows is what caused the damage to the windows. And of course, that cost was not covered. It was in fact excluded. So redoing the window cleaning was excluded, but the fact that the window was cleaning damaged the window so much was that windows had to be replaced. And it was that cost that was in fact covered and not excluded, according to the interpretation made by the court, which again broadly interpreted the coverage language and narrowly interpreted the exclusion. And this is a typical exclusion, and you'll note in this particular policy, the exclusion also included the cost of making good not only faulty workmanship, but also design. And that's a fairly typical exclusion policy that we do see in a builder's risk policy.
So the sort of analysis following Ledcor is really, do we need to engage in a SATVA analysis when interpreting an insurance policy or an insurance contract? And the courts will answer that question by asking and answering, is this a standard form contract or a standard form insurance contract. So let's talk about how this analysis looks in the SureSpan case. So this is a 2021 case from the British Columbia Court of Appeal. In that case, the subcontractor had professional liability policy to cover all parties providing a professional service to a portion of a healthcare project for which the plaintiff was retained to provide services regarding the parkade structure. In that case, the plaintiff subcontractor had committed some errors that were discovered requiring some remedial work, and mitigation cost invoices were submitted to the insurers. Financing charges were, this is in the excess of, 9.9 million in this case. So the plaintiff's action against the subcontractors were issued, and it was their allegation that both parties were insured on the policy. So the plaintiff brought an application for a summary trial against the insurers on whether limits existed on the amounts payable, and the trial judge found that no policy limit applied to mitigation of loss coverage in the professional liability policy. The court determined that the insurance policy was not a standard form policy, and they concluded that the overriding principle is that where the language of the disputed clause is unambiguous, reading the contract as a whole, effect should be given to the clear language, and they cite Ledcor on that. And then only where the disputed language is found to be ambiguous should general rules of contract construction be employed to resolve that ambiguity. And again, they're applying how the court has threaded this needle in Ledcor, which again, Mike Rant, would be a really great way to read SATVA in general. But in any event, for this purposes of this presentation, we're only talking about the context of an insurance policy. And the first question is it a standard form? If it's not a standard form, the next question is there unambiguous language? Can it be read? And if not, where there's disputed language that is ambiguous, then you follow the general rules of contract construction. If the general rules of contract construction fail to resolve ambiguities, then the courts will apply the contra preferentium doctrine that we discussed, where you interpret coverage provisions broadly and exclusion clauses narrowly. So SureSpan is great in giving you a really succinct analysis of how you apply the Supreme Court's distinction in Ledcor. And Karen, I see you're off mute.
Yes, I just wanted to add, I found this case quite interesting because, of course, there were other provisions in the policy, and it's quite a lengthy case, but they go through the entire policy, and there's other coverage in the policy that is subject to a limitation. And one of the arguments, of course, made by the insurer was, this makes no sense that you're saying there's no limitation, because the cost of mitigation can well exceed the other limitations in the policy. And here, the plaintiff had incurred these costs, and they went to the insurer, and then who initially refused to pay, relying on a limitation, had borrowed money and incurred significant costs. But the court had basically disregarded, or at least dismissed, the arguments regarding commercial efficacy and focused on what were the provisions in the insurance contract. And they even commented that despite the fact that the language was a little odd in spots, it was not ambiguous. The court determined it was not ambiguous. So they basically followed the test in, as Mike said, in Ledcor, but also in Progressive Homes.
So building on that, Karen, can I just interrupt a little bit here? We've talked about, obviously, the importance of the policies, but one of the things you often see in the professional liability policies are the exclusion clauses, and they're critically important in a lot of the cases. Mike, maybe I can have you go back to the Terracon case, and maybe you can highlight for us some of the common exclusions that we see in professional insurance, and maybe between you and Karen, you could also address how courts are looking at those as well.
Yeah, for sure. And we've chatted sort of generally about the rules of contra preferentum and narrow versus liberal interpretation. So going back to Terracon then, and then Karen will walk us through the application. Terracon involves obviously a very, very interesting case. Another one sort of up there with SATPA that for anyone with any legal training is sort of beaten into us. So I won't delve into the facts too much, other than to talk about the conclusions with respect to exclusion clauses, right? And so the sort of three factored approach from the Supreme Court when reviewing whether an exclusion occurs is the questions of, does the exclusion clause apply to the circumstances established in the evidence? So, if you're excluding professional services or including professional services, as was the discussion in the British Columbia Court of Appeal case from '84, you just take a general look of, does the evidence support the application of the exclusion? If it does, was the exclusion unconscionable at the time that the contract was made? And then, there again, we could do a whole 90 minutes on what is unconscionability and how have the courts developed their thinking on that. But that is the next stage of the analysis. But if you don't make the unconscionability threshold, that's not it. The third prong of the test is then, should the court decline to enforce the exclusion because of an overriding public policy concern that outweighs the policy interest in enforcing the terms of the contract. And so reading Terracon in context with SAPA, in context with LEDCOR, you've got Terracon's obviously interpreted to a much more broad interpretation outside of the insurance context, but in the insurance context, you've got the analysis that you've got to perform that gives you a separate out in addition to unconscionability, which is this idea of policy interest. And this is where you've got the importance of expert evidence on the insurance industry, what's covered, what's not covered, and commercial efficacy in that context. And that all stems from this kind of third part of the test. But maybe I can leave it there for now, and Karen will sort of take us through some of the exclusion clauses that you'll see, and just wanted to plant this seed as we're going through that as to what the legal standard is for evaluating whether these are acceptable or not.
Well, I guess I should take myself off mute. Okay, so again, just toggling off of Terracon, of course, with insurance policies and commercial design agreements and professional services agreements, you have the argument that you're typically dealing with fairly sophisticated parties on both sides, at least in most instances. Maybe the exception would be the home buyers cases. And so the court looks at that. And of course, in terms of the insurance policies, again, you've got commercial policies put forward by sophisticated parties in the case of standard form policies, and also negotiated between usually sophisticated commercial parties who are familiar with what coverage they can purchase and what coverage may be extra. So there's that issue to keep in the back of your mind. But let's go to the next slide if we could, because what we did here is we've just pulled some standard exclusions we've seen in professional liability policies. So professional liability insurance, and I'm sure you're all well aware of this, but they will typically exclude coverage for obligations that would exceed the common law duties that typically would be applicable to architects and engineers and what they owe to their clients. So for example, if an architect or engineer agrees to a higher standard of care, that could be one example. Other examples cited here are a guarantee of design success or specific outcomes, the promised delivery of a project for a stipulated price. So we're going to look at a case that analyzes that issue, which is a quite interesting case. A commitment to performance metrics or a guaranteed completion by a specified date. And some of these guarantees that we've seen excluded include such things as a fit for purpose, that the design will be fit for the particular purpose. And that's often another issue that's of some debate when you're negotiating these agreements. And I've seen those owners, again, wanting them to be included in contracts, and the professional service provider pushing back and just saying, okay, we'll meet the criteria for the design set out in the specification, that's applicable law, etc. But fit for the purpose is not something that they typically will be prepared to do, because the argument there is it could be offside my insurance. Another example of where you might see the push for a commitment to performance metrics is if an owner is contracting with a professional for example, to produce so many widgets an hour, and it's very important that they meet those production metrics. And so in those kinds of cases, an owner might seek a commitment to performance metrics, and you'll see the push-pull. Is that going to be covered by insurance? If not, the owner is going to have to be aware of the fact that the professional service provider may have to be financially sound enough to backstop that commitment, because it won't be covered by insurance. If we could go to the next slide. Okay, so I've sort of jumped ahead of myself. Typical exclusions from professional liability coverage would include, as I said, contractual liability. That's distinct from what would be the common law standard of care, like the express fitness for purpose representation, again, a warranty or a guarantee. And when we get to the case law, what will be important to look at is sometimes the warranty or guarantee can evolve after the fact. So the parties agree to certain terms of a contract or the professional services, and then during the course of their dealings may amend that contract, and that amendment can lead the professional to being offside or coverage being excluded. So we'll talk about that. Penalty clauses that you see in contracts and liquidated damages clauses. Those kinds of clauses would be typically excluded from professional liability coverage. Again, there are so many factors that go into whether or not a schedule can be achieved, and certainly the professional providing engineering or design services is not the only participant in a construction project. And that's another reason why these provisions are problematic, because those other participants in the construction project may be more well placed to provide such assurances to the owner. If we go to the next slide. Okay, this also may seem kind of trite and obvious, but another typical exclusion is where the professional maintains an ownership interest in the party who's making the claim. And I've taken an actual extract from, again, another professional liability policy, where the specific exclusion is a claim by any individual or business enterprise, or its subrogates or assignees, that wholly or partially owns or manages the professional, or in which the professional has an ownership interest in excess of 20%, or that is controlled, operated, or managed, it says, by you, the professional, unless the claim emanates from an independent third party. And it may seem pretty trite and obvious as to why there would be such an exclusion, because there's the concern here about contrived claims, and that makes sense. If we can go to the next slide. All right, so this exclusion involves activities outside the area of professional knowledge or expertise. And so one of them you'll see here listed as statements of the economic performance or profitability of the project would be expressly excluded from a professional liability policy. And again, in my experience, this can be the subject matter of some debate where it's a specialized project, and that owner may be looking to the professional to provide that kind of a representation. So this can become subject of quite some debate in the negotiation of that contract. Okay, so I think if you could go to the next slide. All right, this must be the last slide I think I've got of the various exclusions. So obviously, an obvious example is fraud. And probably another obvious example is insolvency. However, liabilities for subconsultants, for example, uh, would not be excluded where the architect or engineer retains that subconsultant. They will be typically caught by the professional liability insurance, and they will be liable. So the architect or the engineer retaining subconsultants will be liable at law for the acts or omissions of their subcontractors or subconsultants rather, who are performing that professional service. And obviously, and this toggles off of the comment Mike made earlier at the beginning of his presentation, is professional liability insurance will not cover risks commonly covered under other types of insurance, like commercial general liability, property, etc. And similarly, in those policies, you'll see exclusions for professional liability. And the idea is you've got to go and purchase separate insurance for those kinds of risks. So I thought maybe we turn to some of the case
Sorry,
law to look to see how this has been interpreted by the courts. Go ahead, Mike.
sorry, Karen, just before you move on to the case law, I wanted to raise one point on exclusions, and really it's all part of the overall discussion of exclusions and applications of these policies. Obviously, this is important for determining whether or not, as a professional, you have coverage, and whether you've got a reportable claim and you've got to make a reportable claim. The other side of this that I'm encountering more and more is where you have limitation of liability clauses in a commercial agreement with professionals, and the limitation of liability clause contains a carve out for covered or insured events, right? So the analysis that you're conducting, it's not just as a professional to see whether or not you're covered by something and whether your insurance is going to cover you, but as a claimant, a lot of times you want to conduct this analysis to see whether or not something is arguably a covered event, because it might be your workaround for a rather restrictive limitation of liability clause. And I'm seeing more and more of these LOLs in larger projects, carving out insured services. So just as a note to everyone, obviously, yeah, you want to know as a professional whether you're covered or not, but as a claimant, it could affect your analysis of the viability of bringing a claim in order to recover in excess of a limitation of liability cap.
No,
That's a
that's
really
very
good
true.
point.
Sorry, go ahead, Sarah.
No, that's a really good point, Mike. And Karen, building off everything that you and Mike have said, maybe you could take us. I think I love the cases in this area, and I know some of them are old, as Mike would say. But maybe Karen, you could help us walk through how the courts are interpreting these exclusions, coverage, and the intentions of the parties, and some key takeaways that would be important for our audience.
Sure, I'd be happy to do that. And I can start by saying when I was doing some of the homework prior to putting together this presentation, that I found that there are not a lot of cases that are new in the last few years. I mean, the Alberta Court of Appeal case that Mike spoke about was one of the newer cases, but a lot of the case law in this area is rather old. But they still, the points and principles to be taken from these cases are important. And I always say, and this sounds very trite, it's all about the facts. And one of the things you'll see, the common theme as we progress through the cases and what the courts are doing is they're examining what are the terms of the contract that are governing the relationship between the parties. The courts look at that, and the courts are looking at the insurance policy. And then they make their decisions based on those documents. And like I said, we will see it's all about the facts. So let's turn to the first case I wanted to talk about. Now, this deals with the principle of the prime consultant assuming liabilities for its sub-consultants, and whether or not that sub-consultant would be covered by the same limitation of liability negotiated between the prime consultant and the owner. And what happened in this case is you often see it happen, probably more than people would like. But in this particular case, the Workers' Compensation Board in BC sued their architect and the structural engineer for alleged structural deficiencies. And these structural deficiencies, when you look into the facts of the case, they were discovered in 2002, some 9 years after construction had been completed and they were using the building. They did some type of audit and they found structural deficiencies based on that audit and then sued. And the standard form agreement that was in place at that time capped liability. And if we could turn to the next slide. Okay, so here the provision at issue in the insurance policy, the original, sorry, not the insurance policy, the agreement between the owner and the architect had originally included this provision at section 3.9.1, and it's fairly typical. So it capped liability for the architect. And it says, in any way arising out of or related to the architect's duties and responsibilities pursuant to this agreement, whether such claims sound in contract or in tort, is limited to the amount of $250,000 for each claim and $500,000 for all claims during each period of coverage. And as provided by the architect's professional liability insurance or indemnity against errors or omissions, including the deductible portion thereof, and to the extent only that such insurance or indemnity is available to the architect to satisfy such claims. So what happened in this case is the owner sought to amend that clause that was put forward by the architect, and the amendment was set out as set out below. So they essentially deleted the numbers, the caps of $250,000 and $500,000, and they provided the following. The insurance coverage per claim and for all claims will be as determined by the client and as stipulated in a project-specific professional liability insurance policy to be obtained by the client. And it says the architect and the subconsultants will contribute to the premium cost of such policy to the extent of the premiums that would have been payable by them with respect to the project under their respective general practice policies. And then no contribution to the premium cost will be required if the architect or its subconsultants pay fixed annual premiums to Encon Insurance Managers, Inc. So that is the, I guess, entity that typically provides coverage to architects, for example, and their consultants. So what happened in this particular case, if we could go to the next stage, the next page rather, is as it turned out, the owner omitted to get the required insurance coverage. And the architect and its consultant sought a ruling that their limitation of liability to the owner in this particular case was limited by the agreement 0. And they said it should be 0 because the owner failed to get any insurance. So we shouldn't be subject to the cap of 250 or 500,000. And as it turns out, this is another fact that I don't have on the slide, is the architects in this case confirmed to the owner that they in fact had insurance in place under their standard form policy, and that the cap of liability under that policy was $1 million. So they provided the actual proof, the certificate of insurance, that they had coverage for their work, and the owner was in possession of that information. And the court, when assessing whether or not the consultant was covered by the policy or the insurance that was in fact available from the architect, determined that it was the intention of the parties that and the agreement reached between the parties that any limitation that was available to the architect would be extended to its subconsultant, Stantec in this case. And even if the parties had not specifically agreed to extend that limitation, it was implied. And they say it was implied because the architect wasn't doing the structural work. That work was being done by its subconsultant. Everybody was aware of that. And in fact, the participation of the subconsultant was disclosed to the owner in this case. And as such, it would be unreasonable to assume that such works as landscape design services or engineering would be provided by the architect. And in this case, the court cited the Turcon decision, noting that whether or not an exclusion clause or limitation of liability clause is applicable is a question of interpretation that will depend on the facts of the case. And the court determined that the liability limit of liability in this case was in fact $1 million based upon the insurance available through the architect. And the court also ruled that if the available amount of that insurance had in fact been reduced because of other claims being made to that during that policy period, then it would only be whatever was left that would be available to pay out the claims. Okay. So if we could go to the next case. Okay.
And
So,
Karen,
I
we
think you were going to.
we do have a question if you want to answer it quickly,
Oh,
just if you don't
okay.
mind.
Not at all.
A question has come in, and I just think it might be wise to do this now rather than at the end. Is Karen, Karen or Mike, both of you can answer this. Would you say some of the CCDC contracts that are standardized documents for construction projects in Canada can be specifically excluded in a professional liability policy?
Okay. So when you say specifically excluded, so it would be certain provisions. I'm not sure I understand the question completely, but we all have experienced negotiating amendments to those standard form contracts. And is in fact the amendments or the negotiation of those amendments like what's the standard of care applicable that can lead to the debate of perhaps because of a heightened standard of care that being excluded from coverage. And I think the question's put the opposite way is, can a provision in the contract be, I'm not sure I understand it, be excluded from the insurance to be provided? I mean, I guess if that's the question, when it comes down to it, there are policies that are negotiated, and we looked at a case which was a bespoke policy. So the parties can seek specific insurance. Insurance can be added typically by riders to the initial policy. So it can be the subject matter of a negotiation.
Karen, I've got a specific example if that might help you and Mike answer the question.
Yes.
So with like say a fixed price contract, like for example, the CCDC2 stipulated price or the CCDC2MA, the master agreement between owner and contractor, or the cost plus stipulated price contract provisions, or the 5A, like can you that's the question, is can you take some of those stipulated contracts and exclude them under a professional liability policy? Does that provide further clarification?
Yeah, maybe I can jump in because I think the CCDC regime is often conflated to be interpreted as a standard form regime, where in fact it's not necessarily. And we've all seen, typically speaking, you'll have in the supplemental conditions a lot of work done to the standard form. And so I think the answer is that the analysis is no different than it would be any other contract. It's, the question would be, whether there's anything in the agreement that is subject to the terms of the policy excluded. So in the CCDC regime, I can't think of something specific to the general conditions that would be a pure, for example, as Karen was saying at the front end, a pure contractual obligation that's outside of your professional obligations, in which case would be excluded. You would perform this same analysis, though. You would look at the so-called standard form contract. You would look at the negotiation of it, and you would apply it to the insurance policy as you would any other agreement, even though it's somewhat of a standard form. It's not interpreted by the courts in the same way that a standard form insurance contract would be. It's still a contract that's negotiated between two parties. Someone has just provided you with a bit of a precedent to get you going, right?
I totally agree with that. And the insurance provisions of the CCDC contracts are typically subject to discussions, amendments
Mhm.
from the standard form. And that's dependent upon the nature of the risk involved in the particular project. You may see an expansion of the insurance coverage that might be required from the standard form, or a reduction or modification. So that's where you'll see typically amendments made. Where it's going to be impacting the insurance issue, it will be in the CCDC forms in the insurance sections. So I'm not sure that addresses your questions, but like anything,
Yeah.
everything's subject to negotiations, question of cost. And as Mike was saying, the reason for exclusions from liability often arises from the costs associated with that particular type of liability, and it will increase the amount of insurance required and hence the cost.
Sorry for the disruption, guys. I think that answers the question, and thanks for that. I just
No,
thought it was wise that we deal with it in sequence. But Mike, I believe that you might be addressing our next matter on the Swift case, if I'm not mistaken, on liabilities for subconsultants. If you could just lead into that.
Yeah, as usual, the lawyer from Alberta has to explain the Alberta Court of Appeal.
but this is a home renovation case again, as I recall it,
Home
or a
renovation
home.
case, and I think it's on Vancouver Island too. But the Alberta Court of Appeal, the joke, which perhaps is career limiting for me, but I'll say it anyway. Leave to the Supreme Court, generally speaking, comes in three categories. One where someone's liberty is at stake, one where there's a divided appellate court, and then one is where there's a decision of the Alberta Court of Appeal. So that's my thoughts on the Alberta Court of Appeal. But in any event, they do some fun things. They keep us going. So the Swift case is an interesting case as it concerns liabilities for subconsultants. So I'll give you a little bit about the facts there, and then we can talk about its significance. So the plaintiffs were Mr. and Mrs. Swift. They jointly purchased land on Vancouver Island on which to build a large custom home, as is mandatory for all people in Alberta looking to retire. Mr. Swift signed the architect's agreement containing a limitation of liability clause, limiting the architect's liability to $500,000 for any and all claims which arise solely and directly out of the designer's duties and responsibilities pursuant to the agreement, whether such claims sound in contract or in tort. The limitation clause also extended to the architect's subconsultants. Now, the architect retained a structural engineer as a subconsultant. The engineer designed the home to meet a certain part of the building code when it should have designed it to meet a different part of the building code. And in particular, it's with respect to seismic design criteria. The mistake was discovered and the engineer told the architect it had been rectified. However, the error was not in fact corrected. The trial judge found that the revised design did not meet the building code and that 1.9 million in remedial work was required. He also found that the limitation clause limited liability to 500,000 and that the clause applied to limit liability of the engineer. And this was despite the fact that Mrs. Swift had not actually signed the architect's contract. The trial judge held that regardless, the limitation clause applied to both because Mr. Swift had acted as Mrs. Swift's agent when executing the contract. The holding was that the limitation clause applied to all of the SWIFT's claims together, including a negligent misrepresentation claim against the engineer. The trial judge decided that by reason of the limitations clause, the architect was only entitled to indemnity from the engineer for $500,000 of the $1 million they had paid the SWIFTs in settlement. So the Court of Appeal then comes in. Let's switch the slide over and we can talk about what the Court of Appeal did. So the Court of Appeal decides that they're going to reverse the decision of the trial judge on both grounds. While the court agreed that the limitation clause protected the architect and the subconsultant, it held that negligent misrepresentations made by the engineer during the project were not subject to the limitations clause. So this goes back to Karen's kind of, she sheepishly brings up the trite point of everything depends on the facts, but truly everything depends on the facts. And the Court of Appeal here hangs their hat, well, in part on the fact that the Queen's Bench, as it was justice, missed it. That really this was an issue of misrepresentation and subject to one of the carve-outs. So the court found that the revisions were not original work, did not arise solely and directly out of the designer's duties, and as such, the misrepresentation was not the kind of negligence that the parties intended to be covered by the limitation of liability clause. Not a ton of analysis as to why, but anyway, okay. Consequently, the engineer's liability was not limited. Mr. Swift was entitled to recover the full 1.9 million loss from the engineer. Since he had recovered $1 million from the architect and settlement, he was entitled to a further 900,000 from the engineer. The other part of this is that the Court of Appeal also rejected the trial judge's finding that Mr. Swift had acted as Mrs. Swift's agent when executing the contract. So I had sort of said, well, that's all well and good, but she never signed the contract and was not bound by the limitation of liability clause. Sort of, again, okay. Anyways, I don't think it was well reasoned, but that was their decision at the end of the day. The court concludes without an express agent-principal relationship, Mr. Swift could not affect the legal rights of Mrs. Swift so as to bind her to the limitation clause. Not a lot of analysis as to where the damages flowed as between the two of them and which would be excluded under that or which not, but it was all right because they decided that everything was a misrepresentation anyway, so that was all kind of moot when it comes to defeating the limitation of liability clause. So that's sort of the long and short of the Court of Appeal's decision there. Bit of mental gymnastics, but the takeaway there really is that if you've got a limitation of liability provision, it should expressly limit liability for original work and revisions. Sorry, again, this is a bit frustrating because which original work is never going to have revisions, but okay. Including an express limitation of liability for any misrepresentations in the design work. And then, of course, the other finding, which, okay, maybe I agree with them a little bit more on, all owners must be parties to the consulting agreement or you can't be bound by. I kind of follow them on that. But this idea of original design work versus revisions and just randomly coming up with a misrep is an interesting decision. So, yeah. That's the Swift case. I don't know, Karen, if you have anything to add on
Well,
that.
that's the point. And I agree. It's a frustrating decision. Again, it goes back to my earlier point. The engineer in this case was clearly performing the engineering services they were contracted to perform. And in fact, there was a professional obligation that if there's an error and you realize there's an error, to correct that error. Now, in this particular case, there was a further error made because the engineer didn't correct the error and in fact said it had been corrected. So it was almost like the engineer was being punished. And so, slapped on the hand, you didn't correct the error. That was a misrep, and therefore you're not going to get covered by your insurance. I don't know any other rationale for that, to be honest. But that's the difficulty in trying to predict for your clients or to know what to do in this circumstance. The good thing was they had insurance in place. There was insurance in place. Unfortunately, during the course of the project, there was conduct that took one of the parties outside of that insurance coverage. And that leads as a segue to my next case, which is another old case. And this is a case that was affirmed on appeal, and where leave to appeal to the Supreme Court of Canada was in fact refused. So it's an
It
important
wasn't
case.
from the Alberta Court of Appeal, so they didn't get leave that way.
No, now we're going to Nova Scotia. So we're going further out east at this point. But this again is an interesting set of facts. So the issue in this case is whether the architect's professional liability insurer must indemnify the insured for a judgment arising from a massive cost overruns on what? Another home renovation project. They're always the cases that lead to the interesting issues. So in this particular case, the architect originally provided an estimate of $100,000 for the cost of construction. And here the architect was really closely working with the owner who had purchased land and was building this house on the land, and therefore wasn't interested in knowing what the ultimate cost was going to be. The architect was also involved in advising the owner and had advised the owner to retain contractors on not a fixed price basis, but separate contracts on a cost plus basis. So there was some criticism of the architect for that. And not surprisingly, guess what happened? The architect exceeded, or the budget was exceeded, the original estimate of $100,000. And so there was a meeting between the parties. And this is after they've signed the agreement between them. There's a meeting. And on June 5, the architect gave a new price. And this time they guaranteed that the cost of construction would not exceed $225,000. What happened? Well, the costs ended up exceeding that cap, and damages were assessed by the court at $147,000. And the court determined that there was coverage for professional negligence, but found that there was an exclusion for liability arising from the express warranties or guarantees of the cost estimate being exceeded. So what the court found was there would have been coverage for the architect blowing past its initial estimate, because in doing so, they acted negligently, failing to properly manage, failing to provide a proper estimate originally. But on June 5, when they gave that guaranteed cap cost of $225,000, that became a separate contract with a guarantee that took the architect outside of coverage for their negligence in exceeding that cap. That became a separate contract in effect. If we could go to the next slide. Okay. So I don't know if anyone's got any questions about that case before I go to the next case. But again, the parties during the course of the actual project had negotiations between themselves, and then the conduct during the course of that project took the architect, the consultant to the architect outside of the coverage of that insurance by their specific representation of the guaranteed price. Okay, let's go to the next case. In this particular case, also involves the issue of representations and warranties and the interpretation of an exclusion clause. And in this case, the defendant was required, again, to pay all sums insured by reason of liability in the course of providing their professional architecture or engineering services within the standard of care that was expected, being the ordinary and usual course of the insurance professional practice. And there was a specific exclusion, again, and this was an exclusion to liability arising out of or resulting from or alleged to arise out of expressed warranties or guarantees insured. or guarantees of the insured or any person for whom the insured was legally responsible, or estimates of probable construction cost. So if you can go to the next slide. So this again goes to the same point that I was talking about earlier, and there seems to be a misheading on this last slide. But in the Metam case that we were talking about from the Nova Scotia Supreme Court, on the appeal, the appellants raised the following issues: that the trial judge had failed to consider the negligence of the architect being the principal cause for the cost overruns. And this was completely rejected by the Court of Appeal. They focused on the language in the exclusion clause, which they found to be clear. And they also deferred, quite frankly, to the finding of the trial judge and found that there was no reason to set aside the trial decision. If I could go to the next slide. Okay. So one of the takeaways of this case I wanted to touch on before we go to the next case is, in the case we were just talking about, there were two proximate causes of the loss: the negligence of the architect and the fact that the estimate was exceeded. And this often happens where you've got a covered loss and an excluded loss. And I wanted to talk a little bit about what the courts do in those circumstances, and to talk about the doctrine of proximate cause. So this doctrine looks at what caused the loss. So the issue of causation can arise, like I said, where the loss in question occurs as a result of several factors. So the question to be decided is whether the occurrence of one of the insured perils is sufficient to bring the loss within the terms of the policy. And the problem, like we looked at in the Metcalfe case, is confounded when one of the contributing factors is in fact an excluded peril. And the Supreme Court of Canada in the Ford case ruled that, and we'll talk about what the loss was there. In this particular case, the insurance policy at issue actually provided coverage for riots or losses arising from riots. And it says the term riot shall, in addition to a riot, include open assemblies of strikers inside or outside the premises who have quit work and who have locked out employees. So in this particular example, that's exactly what happened. There was a strike, there was a lockout of employees, and the insured in this case tried to make a claim that coverage was afforded to it under this provision. But the policy went on to exclude liability with respect to loss due to physical damage to the property insured caused by the cessation of work or by interruption of the process of business operation. So in this particular case, as a result of the interruption of the employees occupying the premises, the heating of the building was shut down. There was damages sustained as a result of basically equipment being damaged as a result of a flood. And it was determined by the court that this was the actual cause of the loss, that is the loss of physical damage that was covered by the exclusion. And the fact that this was precipitated by a riot did not afford coverage. So coverage was denied. Can we go to the next slide, please? So then you can have a different situation where there's an independent and concurrent cause. And this can transpire when there are one or more independent causes operating at the same time to cause a loss. And in an all-risk policy, all perils, except for those perils specifically excluded, would be covered. And therefore, the analysis here is to look to see how you can apportion or prove that the loss arose out of the covered peril as opposed to being excluded by the excluded peril. And if you can prove that the loss arose from the covered peril, coverage will be afforded. If not, you will not be able to establish coverage. So it becomes an issue of the ability to prove the loss arising from the covered peril. And that can, in circumstances where there's two or more independent operating causes, can be problematic in terms of being able to prove that. So I've just cited some of the authority for that proposition. If we could move on, because I'm mindful of the time, and I know there's a couple of other cases that Mike and I wanted to get into. Okay, so this is one of those interesting cases that Mike and I wanted to talk about. And this case arose from damages caused to the roof at Pearson Airport. And again, there was insurance in place where there was a cap on liability for the defendant architect of $250,000 for a claim. And the damages in this case that had been sustained by the owner were 10 million, more than 10 million, in fact. And in this particular case, the lower court was asked to determine an issue in terms of the interpretation of the rights under the Negligence Act of the owner to seek compensation from the other parties in excess of the $250,000 cap, and of the other parties being the other co-defendants, which involved, and you can see from the facts, the contracts. They had a contract with the roofer who did the work, the general contractor who was responsible for the overall construction. There was a maintenance provider. And the issue there was whether or not the co-defendants would have to cover off the balance of the liability, or whether or not they could share in the cap on liability negotiated between the owner and the architect. So if we could go to the next slide. So the issue in that particular case was determined by the lower court on what's called in Ontario a Rule 21 motion for determination of an issue. So this was not a trial. This was a motion based on an agreed set of facts and on the interpretation of the limitation of liability in the policy between the architect and the owner. And also consideration of how does Section 1 of the Negligence Act work? And Section 1 of the Negligence Act provides that where damages have been caused or contributed to by the fault or neglect of two or more persons, the court shall then determine the degree in which each of the persons is at fault or negligence, and when two or more persons are found at fault or negligent, they are jointly and severally liable to the plaintiff suffering the loss, but as between themselves, in the absence of any contract, express or implied, each is liable to make contribution to each other in the degree to which they are respectively found to be at fault. So in this particular case, the lower court had found that all of the co-defendants, even those co-defendants that were not subconsultants to the architect, but had separate agreements with the owner where there was no cap on liability under their insurance or their contract, they were able to share in the cap and liability negotiated between the owner and the architect. The Court of Appeal set aside this decision, but not on its merits. Rather, the Court of Appeal said this should not be an issue decided on a Rule 21 motion. This is too complex an issue. The facts are going to be material. And as such, this decision is out there, obviously overturned by the Ontario Court of Appeal. But I can say that I've had this issue raised in cases involving multiple parties in the construction pyramid, where some of the parties tried to seek the benefits, if you will, of a party having a cap on liability in their insurance policy to say, well, my liability should be similarly capped. And the case I'm thinking of, the owner had actually capped the liability of its agreement with one of its consultants at $50,000. and the losses were quite extensive. So if we could go to the next slide. Okay. I guess maybe we can go to the next slide just because I want to deal with some principles. So I'm mindful of the time. So this case just talks about a situation where there was a wrap-up policy and it contained a waiver of subrogation clause, and the court ruled that in the case of in face of such a policy with a waiver of subrogation clause, the party being sued by the owner for damages could not then bring in their subconsultants and contractors. They were precluded from doing so by virtue of the wrap-up policy that prohibited the right to subrogate for those claims against the other parties who contributed to the loss. If we could go to the last slide. I don't like rushing, but I just want to. Okay. These last two slides deal with a few slides deal with an important point, which is, does a covenant to insure constitute an assumption of the risk? And there's case law that says, yes, it does. And again, when you're going through the cases, what you learn is it all depends on the facts. So if you go to the next case, the next slide, this is the Crosslinks Transit Solutions decision of the Ontario Court of Appeal, which involved a project that is constantly in the news. And again, in this particular case, there was a wrap-up policy where the contractor had agreed to obtain insurance as part of its drop down of obligations to the project co-entity. However, they had subcontracted the work to be done to a subcontractor, and under that subcontract, the subcontractor had assumed the risk of indemnifying the contractor and also had to obtain its own separate insurance. So despite the fact that in this case, the contractor had assumed the risk via wrap-up insurance, the court found that the covenant to insure, in this case of the contractor, did not equal to an assumption of the risk. Why? Because the parties had clearly and explicitly put the obligation of the risk and the obligation to indemnify to the subcontractor. So again, as part of the wrap-up or a takeaway from today's discussion, you have to look carefully at not just the terms of the insurance policy, but also of the contract between the parties to determine what the rights and obligations are of each of the parties. And you'll see it in the slides, and I believe these slides will be made available after the presentation. I've extracted some of the pertinent provisions that were considered by the court in that case. One of my last slides deals with a decision of the Alberta court or the BC Court of Appeal, which comes to the opposite conclusion, that a covenant to insure equals the assumption of risk. But again, in that particular case, the takeaway is look at the contract. If you want to contract out of this kind of a result, you must clearly set out in the contract, and here the holding is to enforce an indemnity clause where a contract contains a covenant to insure. A party needs express and unambiguous language that the duty to indemnify supersedes and operates notwithstanding an allocation of risk through covenants to insure. So again, clear language is required.
Thank you so much, Karen and Mike. And if anyone has any additional questions, if you could please just put them in the Q&A. We'll just take a minute just to see if anything populates in there.
Or feel free to reach out. We can all be found very easily on the internet or right there. There you go.
Right there, our faces are there. But not seeing any questions and appreciating everyone's time, I wanted to thank Karen and Mike, and I want to thank all of you for joining us today and for engaging in this really important discussion. And we really hope you found the insights valuable and applicable to your work. And as Mike said, if you have any follow-up questions that you think of afterwards, because we appreciate there was a lot to digest, or if you'd like to discuss how these issues impact your business or your organization, please don't hesitate to reach out to Karen, Michael, myself, or any of your Denton's contacts. So thank you everyone for joining us today and have a wonderful day.